Mr. Sami, good morning.
May it please the Court, good morning, Your Honors. My name is Zahir Sami, representing with my co-counsel Robert Burdick, the appellant and plaintiff Lori DiLiddo. This case comes before the Court on Ms. DiLiddo's appeal of the trial court's...
Can I ask you if the Attorney General is a party in this case, or representing a party?
Your Honor, the Attorney General is a party, but they have not filed an appeal with this Court.
They did file an amicus brief, however.
That's
like
correct.
This morning we got it,
That's
I think.
correct. This morning. I haven't read it.
I take it, Mr. Hayton, that I can anticipate your question, which is if there's something in the amicus brief, which is obviously filed way out of time, giving you an opportunity to respond, you can file a post-argument letter. I don't even know whether you've had an opportunity to review the brief. I haven't. So, Mr. Sami?
This case comes before the Court on Ms. DiLiddo's appeal of the trial court's granting of summary judgment in favor of defendants and the denial of Ms. DiLiddo's cross-motion for summary judgment. Ms. DiLiddo asked the Court today to give effect to the legislature's plain and unambiguous language in Chapter 151B, Section 410. That language states that it is unlawful for any person furnishing rental accommodations to discriminate because of a requirement of an individual's rental assistance or rental subsidy program.
Does that mean that every lease becomes an at-will lease?
No, Your Honor. The lease in this case was not really an at-will lease. The lease allowed the tenant to terminate the lease only if certain conditions were met, and those conditions were requirements of the alternative housing voucher program. Additionally, the tenant with this program actually could conceivably terminate the lease, not move out of the apartment, but sign a new lease, for example, a Section 8 lease for the same apartment with the same landlord. The program required tenants who were participants to search for what the program calls suitable permanent housing, which is basically housing that the tenant could afford without the assistance of the voucher. They could do that in a number of ways. If they found suitable permanent housing by, for example, becoming eligible and receiving a Section 8 voucher, they could terminate their current lease, sign a new year-long lease with a Section 8 lease with the same landlord, and not have to move out. They could find suitable permanent housing perhaps by moving in with a family member, in which case they might have to move out, or if they found an affordable apartment that they could afford without the rental voucher. The program, the regulations promulgated by DHCD under the authority of the legislature.
Well, looking at it from the landlord's perspective, let's say the landlord has leases, year-to-year leases, and then they're confronted with this situation. That policy of year-to-year becomes at will, doesn't it?
Again, Your Honor, this lease is not an at-will lease. The tenant can only terminate the lease if
when
he
the
is required.
Conditions are met.
Exactly. If he is required
it's a
to
30-day
move.
lease.
He must give, the regulations require that the tenant, if he is required to move, he shall give 30 days' notice.
Well, interpreted the way that you want the statute interpreted, might it not be unconstitutional? Because it takes the landlord's property without compensation. It enlists the landlord as a co-subsidizer of the tenant, and it essentially taxes her for renting this property.
Your Honor, the legislature enacted this program, created this program under its police power. It does create it makes certain demands on landlords. Those demands are rationally related to the purpose of the program, and as long as those requirements are reasonable and rationally related, they should be upheld. The purpose of the program was and is to provide low-income disabled individuals with affordable housing until they could find what it calls suitable permanent housing.
Just let me, as I understand it, and correct me if I'm wrong, there's been no constitutional claim.
That's correct, Your Honor. There's been no
Nevertheless, it seems to me that one of the things that the legislature has done is to say you can't discriminate against certain categories of tenants, including public assistance tenants, correct? So if you hypothetically advertise an apartment for $100 a month, those were 2 centuries ago, but I mean, let's assume that it's $100 a month. When somebody has a Section 8 voucher that permits them to pay $100 a month, it is clearly impermissible for the landlord to say, I'm not going to lend to you.
Because you're Section 8 voucher recipient? Yes, it's
Absolutely. But it seems to me it is also, I would think, I don't know this, but I would suggest that if the landlord advertises a rental unit at $100 a month and somebody arrives with a check, Section 8 vouchers saying they can pay $100, it's probably impermissible for the landlord to rethink and to say, well, I've noticed that there's been a sudden increase in the value, so I'm now going to demand $120.
Your Honor, that would be a disparate treatment pretext type case. It would raise a factual question whether the landlord really is refusing to rent to this person because
Correct.
they're a Section 8.
It's a problem. Here you have a different. I mean, it so happens that the landlady in this case is not a single family person. I mean, she has a number of units and she operates, a business.
That's correct.
She
She's
has
not
multi-
Harold Brown, but
let's assume, for example, that in the city of Boston or in Cambridge or in Somerville or in wherever Bentley or anybody's located, the landlady is in a single family, a two-family house. She relies on that income. And we know that, year-to-year leases are very advantageous because students tend to arrive in September and leave in June. And I think we can almost take judicial notice that landlords demand 12-month leases, so they in fact are covered for the long 12-month period. Isn't this a factual circumstance which is a little different? It's not that so much that she is raising a claim of economic hardship, but simply saying it's inappropriate. That's not what the legislature intended under the very broad language of 151B. Section 4.
Your Honor, the legislature in other sections of Chapter 151 has actually taken into consideration those types of situations.
Yeah.
I'd bring your attention to, for example, I believe Section 7 or 7A,
Right.
as well as Section 11, where the legislature actually has made exceptions for two-family dwellings where the landlord resides in one unit and a tenant resides in the other. Now, there is no
And
exception.
those exceptions would apply here?
No, they don't apply because Section 410 does not make that exception. If the legislature wants to, that's in its discretion, but it simply has not made an exception. And more importantly, that's not the case here.
Is there any evidence that Oxford Street Realty knew that the regulations of the program required a 1-month termination provision? I didn't see anything.
Whether they had actual notice,
Knowledge
is an open
The
question.
answer
They
seems
certainly
to
had.
be either no or there is no such evidence, in which case, how can it be discriminatory? They accepted the person as a voucher candidate under the program, had no difficulty with that, and then the lease comes in. They have no knowledge about this 1-month thing. They see it, and they say, oh, my God, this is not in the best interest of our client. They consult lawyers over it. They say it's not in the best interest of the client either. Boy,
Your Honor, they had constructive notice because the requirement was in the regulations explicitly. Their lawyers should have found that. And the only animus required under Chapter 151B is not an actual knowledge that your actions constitute an offense under the statute. The only requisite discriminatory intent, as the case law calls it, is basically the consideration or the figuring into the decision of an improper category, a protected category, or in this case, a requirement of an alternative.
This doesn't quite fit, really, with the notion of discrimination. They had no problem with the tenant, no problem with the program, nothing, except for this one thing that popped up afterwards. It's...
Your Honor, this type of discrimination is basically a new type of discrimination that the legislature added to Section 410 in 1989 after the Attorney General v. Brown decision. Before 1989, the statute read something. The statute read that it was unlawful for a person furnishing rental accommodations to refuse to rent to someone solely because an individual was a recipient of such a rental subsidy or rental assistance. After 1989, the legislature, cognizant of this court's decision in Attorney General v. Brown, explicitly amended the statute so that it stated that now a landlord or his agent could not discriminate because of any requirement. Any requirement is pretty clear and unambiguous language, whether that's
I take it your position is it's a requirement because it's in the regs, which
Yes.
were lawfully promulgated pursuant to the
It's in the
statute.
yes, Your Honor. It's in the regulations. There's been no challenge to the authority of DHCD to promulgate this regulation. And not only is it in the regulations, but the requirement that the tenant search for and accept suitable permanent housing when it becomes available is actually in the statute creating the program.
What if there was something in the regulations that said the landlord has to give the tenant the first month rent free because they have difficulty processing the checks in time or whatever? What about that? Would that be, and then the landlord said, I'm not going to rent to this tenant because I can't afford to give 1 month rent free?
Your Honor, is that 1 month rent free without ever having to pay, or they're
Correct.
paying late?
Correct.
In that case, it could arise to the level of constitutional taking. In this case,
Well, why not here then?
because the cost is purely incidental. As I
It
mentioned,
isn't incidental. It isn't incidental if somebody ups and leaves in the middle of the year, say in December, when you can't possibly get a tenant in December, and the landlord is scrounging around to find a tenant, and maybe doesn't find somebody till April.
Your Honor, the cost is, it's only possible that the tenant will up and leave, and
But no, the tenant has a right to up and leave if certain conditions
if certain
occur.
conditions are
Right,
met, that's
right.
correct. Now,
No such claim has been made here, correct? There may be validity to the claim, but no such claim has been made
that's
here.
right, Your Honor, no such claim has been made, and in this particular case where the landlord owned, there was evidence before the trial court that the landlord owned 30 apartment units. She wasn't Harold Brown, who owned thousands of apartment units, but 30 apartment units is not too shabby.
Can I just ask you this question? The legislation was amended in the wake of our Brown decision, correct?
Yes.
When was the alternative housing voucher program?
It was created in 1995 after the end of rent control in the Commonwealth.
So that was after the statute, the legislature amended the statute, correct? Even if a constitutional claim has not been raised, it is clear, it seems to me, that the regulations provide for this. And it is also clear that the regulations, in the sense that one has, transitional housing almost by definition means it's transitional, so it will stop being transitional at any time that somebody finds permanent housing, correct?
Right.
And that can be at the end of 1 month, 6 months, 12 months, 2 years. I mean, there may be some outer limit. So the regulations may be consistent with the alternative housing voucher program, but it's not entirely clear to me that the legislature had that in mind when it amended 151B 410 to account for the Brown decision.
Well, Your Honor, the legislature, when it created the program, had to have been aware of the amendments. So if they created requirements in the program, they were on notice that those requirements could not be offered as reasons to refuse to rent or to discriminate against a tenant.
I'm troubled, not troubled, I just have a question. I mean, the regulations, I'm not sure are so clear. The regulations don't say landlords must provide a 30-day termination clause in the lease. They don't say that. They just say the recipient has to give the landlord and the housing authority 30 days' notice if they're going to move.
That's right, Your Honor, but the statute, Section 410, is clear. It says any requirement of rental assistance or rental subsidy program.
Now, I read in the deposition testimony, but unfortunately I couldn't find any document to this effect, that one of the other requirements of the program, which is apparently in some other document, is that the landlord enter into, that the lease must be for a minimum of 1 year.
If that's in the deposition testimony, I'd have to review the
Here's
lease.
the DHCD expert. The owner shall reading the the agreements that the department has promulgated between landlords and themselves as part of this program, the owner shall enter into a lease on a form prescribed for the above captioned contract unit with a minimum term of 1 year. And
Yes.
then so in other words, there's two parts here. The landlord has to enter into a lease for 1 year.
Right.
Would that be your interpretation? If
That'd be
that's
my
in the-
interpretation, and it's a lease which is a 1-year lease, except it gives the tenant the right to terminate the lease
On the occurrence of a
on the
single
occurrence of
event.
only certain very specific conditions, which are requirements of the program. Just to wrap up, Your Honors, I see my time is just about up.
No, it's over, Mr. Summey. The orange is just about up, but if you have a closing sentence.
The law is that under Section 410, a landlord or his agent cannot raise as a defense that it is more costly to comply with a requirement of a rental subsidy program. That is precisely what Oxford and Index did, and for all the reasons presented today and in the briefs of the appellant and the amici, we urge the court to reverse the judgment of the trial court. Thank you.
Thank you, Mr. Summey. Mr. Hayton?
Good morning. May it please the Court, Christian Sumito for Oxford Street Realty and
I'm
Jeffrey
sorry,
Index.
Mr. Sumida. Good
Don't
morning.
worry. Defendant appellees. The three main questions presented here are whether an agent discriminated because its principal wanted a year-long tenant for a property, whether the Johansson and Price Waterhouse standard, whether a legitimate reason standing alone would have induced a defendant to make the same decision it did, applies to Section 410, and whether a prospective tenant can force a landlord to change lawful conditions of a rental by virtue of receiving housing assistance.
Mr. Sumida, let me ask you this. Clearly, if this isn't a condition, there's no problem, correct?
Correct.
And you make a plausible argument that this may not be a condition. The question I have for you is the following. This is transitional housing. So while it is correct that there's no requirement that there be a 30-day termination period, transitional housing, as I mentioned earlier, by definition means that you move from transitional housing to permanent housing whenever permanent housing becomes available. And it seems to me that if we were to agree with you, we essentially means that every landlord can simply have a 1-month requirement, a 12-month requirement, which is not, it's not as if your client is insisting on a 5-year requirement. I mean, a 1-year lease is standard in the industry. But that essentially means that it's the death knell of transitional housing, correct?
I don't think so, Your Honor. There are month-to-month leases out there. The question may become if a landlord has a month-to-month lease that they're seeking, finds out that someone is applying in the HVP program or on other housing assistance, and then changes the tune, and then says, I've changed my mind, I want a year-to-year lease. That's not the case that we have here. Here, at all times before Ms. DiLiddo even knew about the apartment, the landlady wanted a year-long lease. And I think it's a fact-specific question.
Doesn't that run into the other requirements that Justice Cordy was mentioning, that there are other requirements that you have a 12-year lease subject to a 30-day termination?
Well, according to the statute, the only requirements on owners, and this is pursuant to 760 CMR 53, which governs here, the only two requirements are compliance with the state sanitary code and the state building code. And then there's also a corollary that, if appropriate, the owner has to comply with lead paint regulations. The Department of Housing and Community Development in deposition, as well as the local Cambridge Housing Authority, CASCAP, both testified that a landlord has to be willing to participate in a housing program. What's happening here under the argument that Ms. DiLiddo and the amici assert is that an owner has to comply, has to participate, has to change the lease provisions as soon as someone who's a member of a participant, rather, in the HVP or another housing subsidy program presents a lease that includes this, what really is fundamentally an at-will provision.
Isn't the plaintiff's argument essentially that a landlord has to treat a publicly assisted tenant better than a tenant who's not on public assistance?
Yes.
Giving them an advantage that nobody else would have?
Yes.
So it's really turning the statute on its head because it results in discrimination against the landlord.
Exactly. Exactly.
But
And it may be a different
could
situation.
could the problem be more fundamental, namely that the Oxford Realty accepted this tenant on the landlord's behalf, correct? And then attempted to change their mind when they saw the lease.
Accepted pending the acceptance by the landlord. And Ms. DiLiddo signed an agreement to that effect, that she's putting down a deposit on the apartment, but that the landlord, the unit owner, had the right to reject her for a reason. The same way Ms. DiLiddo, if she changed her mind and said, oh, I've decided not to rent the unit, if the lease didn't get signed, there might be provision for her to get return of that deposit back.
Mr. Samita, you did not argue that the regulations were beyond the scope of the statute, did you?
I don't think the regulations even provide for the owner to have to be in this position. Nowhere is there a regulation that says, and I understand the court's position that transitional housing by its nature is going to involve a transitional nature. But nowhere in the regulations does it say that a landowner or a unit owner has to sign a lease that affords the HVP participant a 30-day termination window.
No, but
It's not in there.
But it's in the reg.
The regulation provides, and that's what I'm saying. It's possible that the regulations were not consistent with the statute. It's possible, but that claim hasn't been made. She is a recipient of federal, state, or local public aid, correct? And the 30-day notice provision is a requirement of the voucher program by regulation, not by statute, but by regulation. So, strictly speaking, there's a requirement, and your client declined to lease the property because of the requirement. She didn't decline to lease the property because this was somebody on public assistance, but because of a requirement.
Well, I disagree. I think that's an obligation for Ms. DiLiddo as a participant in the program. It's not a requirement on the unit owner. I think if you look at the case law, and some of this case law is after, I know in the briefs there's an issue raised about pre-1989 and post-1989. And the point that I'd like to make about that is, first off, the Blair case, this court 1995, the Powers Court and the Appeals Court 1997, and the Matthews Court, this court 1997, all said that a legitimate non-discriminatory reason can trump violation. But separately,
there may be a legitimate non-discriminatory reason in the sense that she's not discriminating against this tenant because the tenant is on public assistance. The question is this a requirement, a valid, is the regulation that requires a 30-day termination notice a valid regulation? Because if it's invalid, in other words, if it has the effect on landlords that you argue persuasively, perhaps there should be a challenge to the regulation, because clearly if it's a requirement, as one of my colleagues gave in his example, 1 month free rent, what you would do is challenge the regulation and say, you can't do this, but there doesn't seem to have been any challenge to the underlying regulation.
Well, I think it's found that's a regulation binding on owners, then I think it does give rise to a challenge. I would argue that the way the regulation and the statute is written, that it doesn't give rise to a requirement on owners. It's an obligation of the participant to find.
Let's assume it creates a requirement on owners.
That creates a different situation.
But you don't argue that, do you?
I don't think that's the facts of the case, and on this record, on the facts of the case, it's not. That's a hypothetical, and I think that
do you disagree that the regulation requires it? The regulation requires a 30-day termination notice.
The regulation requires that Ms. DiLiddo, if she is to participate in the program, has to find housing where she can leave with a 30-day termination provision. That does not create a requirement that the landlord has to automatically change the lease, agree to a 30-day termination provision when at all times precedent wanted a 1-year lease.
Well,
that's not what's contemplated by the regs.
It does if the landlord signs up for the program.
But the landlord didn't. There's no sign up here. What happens is, and even the DHCD admits this in deposition, in CASCAP says, it's a normal process where the HVP participant looks at an apartment, submits an application, can be rejected for other grounds. And in fact, one of the cases in the MCAD, 1993, Richardson v. Brown, specifically applied to a Section 410 case and said that ensuring that tenant can pay rent is a valid, legitimate reason for refusing a rental application.
Now,
This isn't a situation where this is housing specifically set aside for members of this program.
But if there's a valid requirement, at least on its face, the statute says if it's a valid requirement, then a landlord cannot refuse to accept a tenant if it's a valid requirement.
Except for Blair and Matthews and even the Richardson case, which all kick back and get into the issue of Johansson and Price Waterhouse.
Yeah, but those were not 151B 410 requirement cases.
Richardson was. Richardson v. Brown is one of the
That
few
was a
410
case where
cases
you
in the
had,
MCAD.
there's no requirement, as I understand it in the statute, that the rent be set at a particular level.
Well, there's nothing in any of the case law in any statute that eliminates the Johansson and Price Waterhouse standard from 410. We're creating this carve out where in all of 151B, Johansson and Price Waterhouse applies, and now the Ms. DiLiddo and the amici are arguing that doesn't apply to 410. 410 is the one provision in 151B. Even though there's no case law that says that, there's not one statute that says that, there's no implication that says that. In fact, the case law implies that Johansson and Price Waterhouse applies uniformly to 151B. And that allows the Superior Court or the finder of fact to delve into the situations on a case-by-case basis, which is appropriate. And in some cases, there may be discrimination. There are many cases where there may be a landlord who's
Something in the
discriminating.
record, written in the record, that says when Oxford accepted DiLiddo's application to rent, at which point it knew she was a voucher person, is there a writing that says subject to the lease being approved? Anything like that?
I believe that there is the agreement between the parties.
According to
Is
the
that,
judge,
is that Record Appendix 37, and that was the real estate agreement.
according to the judge, Oxford accepted and approved DiLiddo's application to rent the apartment, period. She doesn't say anything about it's a conditional acceptance. The next thing that happened, the lease come in and can be looked at, and then this problem arose. I'm back to my point. If they unequivocally accepted it, the client, their client, is bound. Ms. Pepe.
But it wasn't unequivocally accepted because there's a finder's fee. If you look at Record Appendix 37 under the real estate fee agreement, it says I/we acknowledge that this fee is in compensation for services rendered and is non-refundable and will only be returned if the application for tenancy is rejected by the landlord or if the applicant declines to take the apartment after being approved prior to signing a lease agreement.
But
That
that's
meant
as
that
between the agent and the landlord, am I correct?
that is between the agent and Ms. DiLiddo.
Right.
The agency relationship was between Oxford and
Pepe.
Pepe, who is the unit owner. And the conundrum here is that had Oxford accepted the lease, then Pepe would have sued for breach of duty. Because then what would happen is...
But clearly Oxford has a way out of this box. If the law doesn't permit this lease, then Oxford simply could have informed the landlord and backed away from the transaction. Just as if the landlord said, I don't want to rent to any women, period. That doesn't mean Oxford is bound to that. They can reject that case, that rental. They have options.
Well, it's a little muddled. First off, in this case, Oxford did go and confer with two separate attorneys, which gave it the same answer and advised you can't sign on this lease on behalf of Pepe because you will be then breaching a duty and in trouble. But second of all, I think that's a different situation. There's even case law that muddles that issue up, that says where the agent is simply following the policy of an owner, of a director, of the officer, that the liability runs to that individual and not very simply the person who's the conduit of information.
But it strikes me that
not the middleman.
it strikes me that that's not an appropriate question for summary judgment at this point. I mean, the trial judge didn't reach that. The trial judge said there's no requirement here, so this case is over.
Right.
Well, the trial judge said it was driven by a valid monetary concern, and so it's not discrimination. It seems to me that what the trial judge didn't decide was whether or not the regulation was proper and whether or not it was a requirement and whether or not it fell within 151B 410.
The trial judge did find that, she did make an explicit finding that's not a requirement, that the only requirements under the case law and under the statute and regs on owners giving rise to 151B section 410 liability are the sanitation, housing code, lead paint, inspectional requirements, things like that. She did make a finding toward the back of her memorandum on that point.
She seems to be wrong on that because the regulation is there.
Well, let me ask you a question about the requirements of the program, because we do have the regulation, which says what it says. The regulation also says that certain documents will be used in administering the program, lists some, and not as a complete list. But those documents, if you look at them, they sort of refine the regulations, or I should say set out in more detail, such as the lease and the agreement with the landlord and the voucher payment contract, et cetera, in more detail some of the explicit provisions that we're talking about here. Are you suggesting that anything beyond if we don't find that the requirement is perfectly explicit in the regulation, but is perfectly explicit in the documents that the department created to implement the program, that it's not a requirement of the program? It has to be in the regulation?
It's not in the documents. Now, I'll give you an example of some of the ambiguities. When you look at the CMR, it refers to a lease. It refers to the ability to revise the lease. And if you actually look at a copy of the lease, which is included in the record appendix, it actually has a block where the unit owner and the tenant could revise the lease and could make it a year-long lease or create different circumstances. Moreover, the fact that Ms. DiLiddo wanted to participate in the HVP doesn't automatically give rise to an obligation to a landowner to have to participate and change the circumstances of the lease. There's difference between complying with the law in terms of inspections.
The department's lease clearly provides that the tenant has the right to terminate on 30 days' notice if in fact additional other housing is found.
And it also has a section where that could have been eliminated.
Well, no, it says other, the section, well, maybe I'm wrong. It says other lease provisions. So you certainly can add to these lease provisions. I don't see that.
Exactly, and that's what Oxford tried to do was make revisions to that lease,
saying that that's not saying that strike the lease.
Right, and put in that section for other that's a year-long lease. That was rejected by DHCD. But if you look at the actual regulations, nowhere does it say that the owner has to comply with this. Nowhere does it say that the lease can't be changed. The only thing that the regulations say is that the unit owner has to comply with lead paint where applicable, inspections for sanitation, has to be up to the housing code, which all landlords have to do anyway as part of the law, whether it's an HVP program member, a Section 8 program member, or just a tenant such as you and me.
Thank you.
Thank you, Mr. Sunita. We'll take a short break.